All right, hope everyone's having a good day. We're going to read addendum to the pre-sentencing report. This is the pre-sentencing report before the judge sentences Schaeffer Cox. The probation department wrote up a report for the judge just like the defense and prosecution did. It was basically a rubber stamp copy of the prosecutor's sentencing memo. Mr. Camiel, working with Mr. Cox, went through it and pointed out all kinds of lies and inconsistencies and attached evidence to prove the prosecution was lying intentionally. Ms. Hensel, the probation officer, responds or tries to respond to these by saying, more or less, we succeeded in keeping the truth out of the trial, so now our lies get to become facts as far as the process is concerned. The following is the back and forth between Mr. Camiel and Ms. Hensel. Addendum to the pre-sentencing report, United States Dishonorable District Court for the District of Alaska, United States versus Francis Schaeffer Cox, case number 3:11-CR-00022-RJB-1. Objections to the pre-sentence report. Based on objections submitted by the government, substantive changes and or corrections were made to paragraphs 28, 35, 50, 82, 84, 85, 95, 99, 105, 106, 115, 116, 122, and 132, paragraph 78A and 83A were added. Footnotes were added to paragraphs 115, 121, 164, and the footnote to paragraph 118 was changed and moved to paragraph 119. Based on objections submitted by defense counsel, changes were made to paragraphs 23, 34, 42, 51, 57, 79, 80, 86, 132, 133, 222, and 223. Footnotes were added to paragraphs 29, 31, 34, 38, 42, 51, 57, 68, 69, 72, 78, 84, 86, 97, 102, and 122, and paragraphs 222A was added. Based on an error in the paragraph numbering sequence in the draft pre-sentence report, paragraph 56 under the heading Criminal Convictions was changed to 156A. Based on additional information received after submission of the draft pre-sentence report, changes and or corrections were made to paragraphs 127, 165, 173, and 181, and paragraphs 176A, 176B, and 203A were added by the government. Paragraph 135. The government submitted that the following information: we agree with the application of the 4-level enhancement under 2K2.1B6B. We would add that the 4-level enhancement also applies under 2K2.16B6A for possession of firearms and ammunition with knowledge, intent, or reason to believe that it would be transported out of the United States. Barney testified that the plan was for Cox to leave Alaska and to flee to the lower 48 via Canada. Barney and Cox went to the Bradway Road shed, and Barney and CI1 retrieved, which would be Gerald J.R. Olson, Hell's Angel wannabe, retrieved Cox's items, including firearms and ammunition, which they placed into Barney's truck, and Barney drove them back to Barney's house with Cox for Cox to bring with him when he left the state. See page 48 of Barney's testimony, 6/7/2012. Cox's firearms, including Sten machine guns, silencers, grenades, Browning, and ammunition, ended up in Barney's trailer. Cox had packaged and wrapped some of the items at Barney's house before moving them into the trailer. Barney and Cox drove that trailer to the ice park on the day they were planning on meeting up with the truck driver to get Cox to the lower 48. Okay, page 2. Response. The probation officer agrees with the government's analysis that the enhancement also applied under 2K2.1B6A by the defense. Defense counsel submitted the following unresolved objections. Defense counsel objected to the inclusions of paragraphs. Oh my goodness, I can't read all those numbers. I don't know if it's important to read all these freaking numbers, man. This is all going to be uploaded to the Dropbox where you can download it, but I don't think it's important to read these numbers. And inclusion of the paragraphs would be inappropriate with regard to the factual matters in Mr. Cox's pre-sentence report. Response. Paragraphs blah 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 reflect in part Lonnie Vernon's interest in acquiring a silencer and grenades, as well as discussions in which he partook to acquire those items and his subsequent arrest by authorities. The defendant and Lonnie Vernon were convicted of conspiracy to possess unregistered silencers and destructive devices and conspiracy to murder in case 3:11-CR-00022-RJB. Because the defendant and Lonnie Vernon were convicted of a conspiracy to possess the silencer and destructive devices, these paragraphs are appropriately included in the pre-sentence report. Paragraphs 58, 65, 77, 102 reflect conversations Lonnie Vernon had with others that involve wanting to kill judges, district attorneys, and law enforcement officers. Some of the conversations included Lonnie Vernon discussing that he wanted to kill a federal judge and his family and an Internal Revenue Service officer. Paragraph 65 reflects that Lonnie Vernon introduced the defendant's plan to CI2, and CI2 was partially resistant to harm being inflicted on the families of any targets. And paragraph 65 also reflects that Lonnie Vernon and CI2 discussed to some degree the defendant's situation. Paragraph 77 reflects that Lonnie Vernon discussed killing a prosecutor and cop, as well as his troubles with the IRS, while the defendant was present. Paragraph 83 reflects that Lonnie Vernon attempted to get the target list from Anderson. It is noted that the target list was specific to the defendant's case. Because the defendant and Lonnie Vernon were convicted of count 12, conspiracy to murder, and the objected to paragraphs reflect Lonnie Vernon's discussions related to that conspiracy. These paragraphs are appropriately included in the pre-sentence report. Paragraphs 59, 67, 80, and 81 reflect conversations that Lonnie Vernon had with others, to include CI1, in which Lonnie Vernon discussed his intent to harm a federal judge and his family and an IRS officer. Paragraph 80 reflects that the defendant was present during at least one such discussion. Paragraph 116 reflects Lonnie Vernon's suicide letter, which was found by investigators after his acquisition of the illegal weapons. The paragraphs are included in the defendant's pre-sentence report for mainly two reasons. First, the defendant conspired with Lonnie Vernon to acquire a silencer and grenades, which items could facilitate Lonnie Vernon's plan to murder federal judge and his family and the IRS officer, intentions of which the defendant was aware. Secondly, the defendant and Lonnie Vernon were convicted of conspiring to murder government officials. It is the probation officer's assessment that Lonnie Vernon's state of mind and willingness to kill and be killed in the name of his and defendant's cause was paramount to the defendant's plan and may have influenced the direction of this investigation. Defense counsel questions the investigation in some of the following objections. Paragraph 23 explains Lonnie Vernon's association with the Alaska Peacemakers Militia and the Alaska Assembly Post, and explains Lonnie and Karen Vernon's situation with the IRS and the federal judge involved in their civil case. Because Lonnie Vernon's reaction to the IRS and federal judge is included in the following paragraphs, the information regarding the IRS and the federal judge was not removed for the above stated reasons. Defense counsel objected to the description of Lonnie Vernon's association with the Alaska Peacemakers Militia and the Alaska Assembly Post. Changes were made to paragraph 23 regarding Lonnie Vernon's association with those entities. 2. In his objections to the pre-sentence report, defense counsel included a number of email communications between those involved in the investigation and prosecution of the defendant's case, which emails were provided in discovery. With regard to June 2010, defense counsel provided the following statement. In June of 2010, Mr. Cox attended a meeting which included CI2 Bill Fulton. At this meeting, Fulton pressured Mr. Cox to come up with a plan to arrest judges. Mr. Cox said he had no plan. Here is the FBI's take on that meeting. From Espeland Derek D. Sent Monday, June 14, 2010, 8:10 p.m. Locature, Lisa, Sandra Klein, Bruce Milner, Sam Johnson. Subject, SC-Fairbanks. Schaeffer Cox was exposed as a self-aggrandizing fraud. He did not have a plan at all. Even if he had a plan, there was allegedly other plans to off SC 48 hours after the revolution began. SC has gone from a cadre of 24 down to 2. Him and his number 2, Les Derby. You need to understand the significance of that paragraph that I just read. Okay, the FBI was convicted, Schaeffer Cox, of having a plan to murder federal agents, but yet in this particular email from Derek Espeland, FBI agent, he said that he did not have a plan at all, right? And even if he had a plan, there was allegedly other plans to off SC, which means to kill him, which is what Schaeffer had been saying all along. Response. The pre-sentence report indicates that in October 2010, Cox asked Anderson to find information related to Alaska State Trooper MJ, and by February 2011, Cox developed the 241 plan. The defendant's objection appears to reintroduce the defense strategy that going to page 4 here, that CI2 initiated the 241 plan, a defense strategy which was rejected by the jury during the trial. No changes were made to the pre-sentence report as a result of this objection. Number 3, paragraph 57. Defense counsel wrote, Mr. Cox also denies that he asked him to get C4. Rather, Mr. Cox said he had a guy who worked for him who knew a guy who knew a guy who could make C4. Government Exhibit 3, page 13 and 14. Response. The pre-sentence report in paragraph 57 reflects that the defendant discussed wanting to get C4 explosive. The exact quote by the defendant and referenced by defense counsel is inaudible from, I had a guy that works for me that has a guy he knows who knew a guy who knew a guy who is a bomb maker over in Iraq. And he said he'd make us some C4. Cox then continued by saying, I asked him how much, and I didn't get a price back. So he said, how much would you spend and I'll send it on down the line. I don't know, $1,500 maybe. What depends on the shelf life. The defendant, CI1 and Lonnie Vernon, continued discussing the prospects of getting C4, and the defendant stated, what I thought we'd do, make little Hershey bar sized ones and put them in salmon fillet packers. The discussion continued, and the defendant stated, and that you don't talk about, but what do you need that for, Who knows? I don't know. Why do you have a gun in your nightstand? No changes were made to the pre-sentence report as a result of this objection. Number 4, footnote at paragraph 57. Defense counsel wrote, Mr. Cox maintains that Mr. Brakefield had his years confused. Mr. Cox saw Brakefield at the event held in 2009 before Mr. Cox became fearful of Fulton and Bennett. Mr. Cox's fear of Mr. Fulton and Mr. Bennett occurred after the Blondies meeting in which Fulton pulled a knife and threatened to kill Les Zerby, and when Fulton was told that Mr. Cox did not have a plan to arrest judges. From that point forward, Mr. Cox was fearful of and tried to avoid Fulton. Evidence of this includes the fact that Mr. Cox did not want Fulton to know that he was still in town on February of 2011 and that Mr. Cox refused to meet with Mr. Fulton. Evidence of Mr. Cox's fear of Fulton is also contained in an FBI email where the agents note that Mr. Cox refused to meet with Fulton and even told Olson, CI1, that he did not want Fulton to know he was still in Fairbanks. Why would he refuse to meet with Fulton and not want Fulton to know he was in Fairbanks if he was good in terms with Fulton? Richard Sutherland, Sandra Klein, plan, Friday, March 4th, 2011, 5:33 p.m. Schaeffer Cox is not willing to meet with CHS2, does not want him to know he is still in Fairbanks. Wants CH1, which I think is J.R. Olson, to broker the deal. Schaeffer Cox willing to meet Trucker to discuss transport, Rick Sutherland. During February the 4th meeting, Mr. Cox told Olson and Vernon to stay away from Bill Fulton and Aaron Bennett as they were going to get them in trouble. Response. The defendant's objection to reintroduce the defense strategy that Cox only participated in the offense because he was afraid of CI2, a defense strategy which was rejected by the jury during the trial. No changes were made to the pre-sentence report as a result of this objection. Number 5, paragraph 68. Defense counsel wrote, Mr. Cox denies that he made the statement. There is no recording for the February 6, 2011 meeting, and thus the only evidence comes from CI1 in an email dated February 18, 2011. The FBI acknowledged that CI1 had not always been accurate with them. Lisa Locatio, Richard Sutherland, tapes from last night. Friday, February the 18th, 2011, 8:57:55 a.m. We need to listen to audio before we tell Scrocky. CHS, which stands for Confidential Human Source, info has not been 100% accurate before. SSA Lisa A. Locatio, Federal Bureau of Investigation Counterterrorism Program, JTIF. Response. The defendant's objection appears to reintroduce the defendant's strategy that CI1 was not a credible, a defense strategy which was rejected by the jury during the trial. A footnote was added to this paragraph to note the defendant's denial of the reported statements. Number 6, paragraph 70 through 74. Defense counsel wrote, as to the February the 12th, 2011 meeting, FBI Special Agent Sutherland wrote in an email dated February 13th, 2011, listen to most of audio. Great quality CHS info validated. Do not feel it will support prosecution. Response. The objection is noted for the record, but no response appears warranted other than to note that several events involving the defendant and others unfolded after The conversations noted in paragraph 70 through 74. No changes were made to the pre-sentence report as a result of this objection. Objection number 7. Paragraph 85. Defense counsel wrote, February 19, 2011 recording. The recording of the February 19th meeting reveals that Mr. Cox ultimately rejected the 241 plan. Mr. Barney, yeah, we're all in this together, but I know right now the atmosphere, I don't feel it's right to. If we take up arms, it's going to be, I wonder if anything would really even come out of it other than we'll be dead and our wives and children will be left to themselves. I don't think that people around us won't see us as martyrs. Miss Vernon, Speaker, no. Speaker number, no. Mr. Cox, it'll be a fruitless gesture. Okay, that's rejection of the 241 plan. After February 19, 2011 meeting, FBI Special Agent Sutherland wrote in an email dated February 19th, meeting is over, no immediate threat to LEO, which I think stands for law enforcement officers or judicial official identified by CHS. This email supports the contention by Mr. Cox that there was no agreement to implement the 241 plan. Response. The defendant's objection appears to reintroduce the defendant's strategy that the defendant rejected the 241 plan, a defense strategy which was rejected by the jury during the trial. No changes were made to the pre-sentence report as a result of this objection. Objection number 8, paragraph 86. Defense counsel wrote, there was no real grenades in Mr. Cox's possession. None were found. The only basis for the claim that actual grenades was present was a statement by CI1, which is $300,000 whore J.R. Olson, that was uncorroborated by any recording or any search or any other witness. Moreover, in an email by AUSA Scrocky dated March 5th, 2011, Mr. Scrocky states, additionally, I am trying to verify source reporting. For example, this morning I asked a question about how we know the grenades are on the Barney property. I received info that source reporting says there's grenades on Cox's property. I am listening to that recording now. It is 4 hours long. The first few minutes, Barney and CS are talking about grenades, but talking about a rumor that Cox has grenades off Wainwright. Nobody, and I mean up to now, nobody says there are grenades on the property. So unless somebody can verify they've listened this, I have no choice but to plow through it to see if I can verify that it exists later. It might be there. It'd be great if it was, but we have to verify. It'd be great if it was. Hey, Scrocky, you remind me of one of those little devils that you don't have a life of your own and you're still full of evil and reprobate. You don't have a life and you'd like to prop yourself up, that you got to spend hours listening to recorded conversations of, decent men who work hard because you don't have the aptitude to work hard yourself. So you just listen to hours of conversation on other people's private conversations, and you said it'd be great if there was. You'd be great because you can allow to put innocent men in prison. Absolutely insane. You said it'd be great if there was. But we have to verify. While the source is doing scary and thorough work, I think it's fair to say his verbal reporting is not 100% accurate, and that is understandable. Emphasis added. Response. This paragraph was slightly modified and a footnote was added to reflect the defendant's objection. It is noted that these alleged grenades were not used in any guideline calculations. Objection 9, paragraph 115. Defense counsel wrote, the Sten machine gun mentioned in this paragraph was determined not to be fully automatic by the crime lab. The Sten was a different firearm than the one Mr. Cox admitted possessed, which was fully automatic. Response. This paragraph reflects that a Sten machine gun was found at the Vernon's residence. According to the government, the gun was found to be fully automatic, but the information had not been presented in trial. Objection 10. With regards to the 241 plan, defense counsel wrote the 241 plan is referenced at paragraphs 70, 73, 79, 80, and 85 of the draft PSR. February 12, 2011. During this conversation, CI1, $300,000 whore J.R. Olson, suggested 541, which was rejected. Government Exhibit 14.5. The government introduced only a portion of this conversation in Government Exhibit 14. Some portions that were not introduced, including Mr. Cox saying, so we're all on the same page. The plan is for 241 to bluff it, pray, and to work towards it not being a bluff, and then at the moment my plan is to hide, to avoid if I get busted. If I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi. Mr. Cox did state, Mr. Cox, all right, well, let me give you my guy's thoughts. I really appreciate your thoughts on that. My thoughts on 2-for-1 is that we're not strong enough position to execute more than once. We're not in a strong enough position to follow through, and so at this point, what we should do is everything we can to avoid it. But that we should do is we should bluff, if it for all it's worth, pray for God's protection and shield and hand, and work and train to get ready to where we can turn that 2-for-1 into a reality instead of just inaudible. Mr. Cox, so that sums up my 2-for-1 sums up 2-for-1, and my position is he also stated, going to page 8. Oh, he put a note here. This means that the affidavit in the warrant filed on is based on all lies, and they know it. There's something anyway. Mr. Cox, maybe it's good that we've got a mutual standoff, but I'd say from my part on order 2-for-1, bluff it, pray, and train so that it can become real. And in the meantime, total Gandhi. The government attorney interpreted Mr. Cox's many different statements at this meeting as just kicking around ideas and speculating. In a February the 13th, hold on. In a February the 13th email, Mr. Scrocky stated, from Stephen Scrocky, Serpent Scrocky, Sunday, February 13th, 2011, 4:13 p.m. to Karen Loeffler, daughter of Belial, subject Schaeffer Cox, long email, sorry. Listen to conversation from last night. In summary, they are kicking around ideas. My advice, do not arrest him if he doesn't show, but issue the warrant and let it sit. With the source in place, we'll have the best idea of what's going on, and it won't agitate Cox's followers. You might want to give Mike Gray and the SAC a call tonight too. The SAC can verify with Rick what I'm saying. 2-for-1 stands for if they take out one of us, we take out two of them. But they discuss not being strong enough to impose their views on the rule of law. They discuss everything from 2-for-1 to fleeing to rapture and coming and waiting for that. In my view, the FBI source is pushing Cox a bit too hard on not getting arrested, and the source agrees too much in moving their plans forward, which would generate a response whether violent or not. The source adds, why don't we make it a 5-for-1? Not a good idea. FBI has to fix this. After some discussion of 2-for-1, Cox says, we're just speculating here, and I'd want to hear about where you stand. Cox does say he would be morally correct in shooting a judge, but adds that he doesn't want to do that. So he makes the big pronouncement, then backs off, the typical will but not just yet type stuff. This is all about him. He spent almost 2 hours reading and explaining his paperwork, in my view, just to lay out that he's smarter and in charge. It's clear he doesn't understand it, and is getting it from somebody else. He reads it to be the leader of the group, which he really is. Cox's stated thoughts are, we are not strong enough to execute or follow through, and says they should do everything we can to avoid it. He says they need to work and train and get ready for when they might have to respond. In response, the source says we can get other militias to support us. Another example of pushing. Cox says we want to bluff them and play and train. It's pray. He claims the police are afraid of all of them, and asks, what do you guys think about this then? And after getting various responses, none saying let's go grab and harm people tomorrow, he ends it with bluff it, play, and dream. No, it's pray Scrocky, Serpent Scrocky, but adds something that sounds like pull guns. He says at the moment his plan tomorrow is to lay low if he gets caught, to play Gandhi, not Rambo. Again, he qualifies almost everything. It's very obvious he wants wiggle room. Agent Sutherland wrote the following regarding the CI1, which is $300,000 whore Olson, meeting with Mr. Cox on this date. Cox discussed Operation 2-for-1. Cox said that there would not be a 2-for-1 response if Vernon's house was seized. Cox said that he had lost his business and his residence, and that Vernon needed to be prepared to lose his. Cox said that they did not have enough support to pull off a 2-for-1 operation and survive. Response. This objection is noted for the record, but it does not appear to warrant a response, as the defendant presented his case to the jury and was convicted. No changes were made to the pre-sentence report as a result of this objection. Number 11. We regard the KJNP security detail. Defense counsel wrote, while the government has alleged that this event was a part of the conspiracy to commit murder, it appears that the jury categorically rejected this. A letter from a jury to Judge Bryan in advance of the sentencing of co-defendant Barney stated that, in particular, I don't think that the prosecution understands that the only criminal charge stemming from KJNP security detail that resulted in a conviction was Coleman's possession of an illegal destructive device. The jury categorically rejected the prosecution's allegations that a murderous plot to kill federal officials, but was instead a plan to lawfully defend themselves if attacked by non-uniformed agents who began shooting without identifying themselves. Emphasis added in original juror letter. Response: the parties are familiar with the entire contents of the juror letter and believes that the court and the parties had already examined and discussed the circumstances of the KJNP security detail as it relates to the conspiracy at great length. No changes were made to the pre-sentence report as a result of this objection. Page 10. With regard to KJNP security detail, defense counsel wrote, the FBI case agent summarized... Excuse me. The FBI case agent summarized the meeting where Mr. Cox planned for his KJNP appearance on November the 23rd, 2010 in the following email. From Richard Sutherland, Matthew Gunty, Monday, November the 22nd, 1850. Subject: Cox update. Here is a super brief update so you can try to answer some questions if you are asked. Number 1, Cox had a court date for tomorrow for a state weapons charge. 2, the troopers continued his case to December the 10th. Cox had a 7-step plan to coincide with his court date. 4, he calls the plan Operation Nehemiah 5. His plan involves civil disobedience, media coverage, and a declaration that the Alaska court system as void and possessing no authority over him. He plans to call the troopers and demand a truce. 7, he will provide identification to his followers to identify them to troopers so that the troopers leave them alone and refer them to Cox. 8, he has a TV appearance on live TV scheduled for tonight to kick off his big plan. In recorded meeting with CH5, he stated over and over that he did not want violence and that he did not want to see any cops hurt. He has armed a militia security team with C5 gas and Hornet grenades as a diversion squad if needed. There is more to the overall plan, but this is an overview. Response: this objection is noted for the record, but does not appear to warrant a response from the probation officer. Number 13, with regard to the defendant's belief that the defendant believed a federal hit team was out to kill him, defense counsel wrote, while the government has denied that there was ever a federal hit team sent to kill Mr. Cox and his family, Mr. Cox repeated this fear to a large number of people, to include his wife and father. He truly, if mistakenly, believed that this to be the case. In addition, Mr. Cox was reinforced by comments made to him by an MP at Fort Wainwright. Steve Gibson testified at trial as follows. 15-195-196. Okay, that's the bottom of page 10. I'm going to stop here at the top of page 11. I'm stopping at the top of page 11. All right, we're going to pick back up with page 11. The objection, okay. With regard to the defendant's belief that the defendant believed a federal hit team was out to kill him, defense counsel wrote, while the government has denied that there was ever a federal hit team sent to kill Mr. Cox and his family, Mr. Cox repeated this fear to a large number of people, included his wife and his father. He truly, if mistakenly, believed this to be the case. In addition, Mr. Cox's fear was reinforced by comments made to him by an MP at Fort Wainwright. Steve Gibson testified at trial as follows. While he was there, I had asked him about Schaeffer Cox, and he told me that Schaeffer Cox was the guy that lived there locally in Fairbanks. He told me that Schaeffer Cox, in his opinion, was crazy and was currently going through some issues with OCS. He said that Schaeffer Cox, it looked like, was going to lose his son because he hadn't been participating in either a hearing or something to do with OCS. I don't know all the details with that. Affirmative. And his exact words were that with some of the issues that had been going on with Schaeffer Cox, that the OCS issue actually may resolve the problem that they had because he could. He said that Schaeffer Cox had made some threats in reference to OCS. He said that he had said that he was not going to give up his son and that he wouldn't let anybody take his family. And I believe the exact verbiage he had used was that Schaeffer Cox would turn Fairbanks into a bloodbath before he would give up his child. And so the U.S. Marshal said, based off that statement, that when OCS would go to Schaeffer Cox's house to get his son, law enforcement would be present. He also stated that they believed, based off his statement, that Schaeffer Cox would probably use force to prevent them from taking his child, and that if he did so, that he would most likely be shot and killed in this scenario, emphasis added. Gibson also testified that he was told by the U.S. Marshal that whatever the problem was with Schaeffer Cox, if he was killed with OCS attempting to take his son, then obviously anything that had to do with him wouldn't matter anymore. Gibson went on to say he was so alarmed by this conversation with the FBI that he sought out and contacted Mr. Cox, relayed what he had been told. This information added to Mr. Cox's paranoia that the federal government was trying to engage him in violent confrontation to kill him. The law enforcement people who were investigating Mr. Cox recognized his paranoia about being the focus of a federal hit squad. The following email is from Fairbanks District Attorney Michael Gray, page 12. Sent Tuesday, January 25th, 2011. Scott Mattern, Joseph Delaire, Andrew Baldock. Subject: to follow up on my conversation this morning, we must be careful in responding to Cox to not act like him. He tells his folks that an assassination squad is up from Colorado to kill him. His homies talk about the same among themselves. He hears it from somebody that heard it from him, and all of a sudden it's confirmed. Response: the objection is noted for the record, but does not appear to warrant a response from the probation officer. 14. With regard to the list, defense counsel wrote, Anderson testified that he and Mr. Cox discussed the collapse of the U.S. government and the imposition of Stalin-esque martial law, whereby families were being seized. Anderson testified that he and Mr. Cox discussed. Question: did those conversations evolve into an agreed-upon plan of some type with you and Mr. Cox? Not a specific plan. It was just generally, if it comes to that, we have to identify who was doing it and take them out before they could come for us. I mean, kill them before they could come for us. Kill them before they came for you? Yes, that was kind of subject of the discussion. As part of the subject of your discussion with Mr. Cox, did you engage or become someone to do something for him in respect to that conversation? Yeah, there was an idea of collecting information on who any potential enforcer could be, who could potentially carry out those orders, collecting home address information. Is that what you did? I did some. With Mr. Cox's knowledge, yes. Thus, this list was only to be used if the government collapsed and martial law was imposed and government officials began seizing families. As to various names found on notepads in Mr. Anderson's residence during the search, Mr. Anderson testified that Mr. Cox asked him to find out where WW lived so he could go talk to her. Day 6, page 53. As Anderson was unsure he had the correct WW, he testified he went by her home and took a photo of her license plate to try to run her name. At a later time, Anderson testified that Mr. Cox said he needed to know where she lived because if she hurt his family, he might have to put a bullet through her windshield. Mr. Cox denies he made this statement. In addition, Mr. Cox told Anderson he thought there was a hit list out to get him and wanted to see if Anderson could find the names of the hit team members. Anderson testified that Mr. Cox never said he wanted to overthrow the government, and he never heard Mr. Cox espouse killing people to overthrow the government. Anderson said that he and Mr. Cox discussed that if the government collapsed, there might be the need to protect themselves with deadly force. Cox never said to Anderson that he was going to shoot anyone on the list. Anderson testified that he had about 15 to 20 names on the database, and those of a few of the names came from Mr. Cox. Day 6, 147. The only name on the single-page document Anderson on his own entitled Federal Hit List was a U.S. Marshal who Anderson looked up on his own, not at the request of Mr. Cox. Day 6, 142. As to the list, even the government expressed uncertainty as to the intent behind it. Special Agent Sutherland wrote in an email dated March 3, 2011, a mere 7 days before the arrest, any idea of Cox's intention with the list, especially in light of the fact that he is leaving? Is this the target of LE and judges? Yes, the list of LEOs and targets, no known intentions other than more potential deterrence. Response. The objection is noted but does not appear to warrant a response from the probation officer. Paragraph 125, number 15. Defense counsel objected to the assessment that the defendant made false statements during his testimony and provided the following statements to refute paragraph 125. We will address each of the alleged false statements in order contained in paragraph 125. The defendant testified that he did not tell anyone to make a target list. While Mr. Cox admits Mr. Anderson to look up names and addresses, he never used the term target list to describe this task. There was no recording where Mr. Cox uses the term target list, and Mr. Anderson did not testify that Mr. Cox used such a term. The actual question to Mr. Cox was, did you tell somebody to write a list, a target list, of people to get killed? Mr. Cox answered no. That he did not tell Anderson to write down names. Mr. Cox fully admitted at trial that he did ask Anderson to look up a number of names and addresses. 14. Page 14. That he did not tell Anderson to create a list. Mr. Anderson described evaluating a database of names and addresses. Regardless of what is called a list or database, it was not a material fact. Number 4. That he never had a TSA employee on a hit list. Mr. Cox has denied that this was a hit list. Number 5. That he did not give the names of WW or NC to Anderson. Mr. Cox did not recall providing Mr. Anderson with these names. His recollections may have been faulty, but he did not willfully make a false statement. Number 6, that he did not know the names on the list came from. Mr. Cox admitted to providing Mr. Anderson with some names. Mr. Anderson looked up many other names on his own without Mr. Cox's knowledge. Number 7, that he never asked Anderson to conduct surveillance. Anderson never testified that Mr. Cox asked his to conduct surveillance. Anderson said that on his own he went to the address of WW to try to confirm she lived at that residence. See transcript 653. Anderson testified that he did not engage in any kind of surveillance other than to get a photo of the license plate. 6124. That he wanted to see Anderson because he was leaving, but not to get lists from Anderson. Anderson testified that Mr. Cox had come by his house, he wasn't home, and left a phone number. Anderson called Mr. Cox. They discussed Mr. Cox's court proceedings and other matters. Mr. Cox was on the run at the time. At the end of the call, Mr. Cox asked Anderson, "Do you have something for me?" To which Anderson said, "Uh-huh." Then Anderson asked him to meet me in town. Anderson testified, I thought he was coming for the database, but by the time I had already gotten rid of it and I was trying to hire him in, I was trying to hire him in to talk to him. Anderson testified that when he met with Mr. Cox at the very end of our meeting, I just said, "Oh, by the way, I destroyed that thing." Anderson stated that Mr. Cox said nothing but seemed surprised. Number 9, that he had no interest in the list. CI1, which is $300,000 whore J.R. Olson, wanted the list and volunteered to contact Anderson to try to get it. By this time, Mr. Cox's primary interest was leaving Alaska. Number 10, that he had asked Anderson to find out where WW lived to do surveillance. Mr. Anderson confirmed that Mr. Cox did not ask him to do surveillance. Mr. Cox did not recall asking Mr. Anderson to find out where WW lived. That he said WW might get a bullet through her windshield. While Mr. Anderson testified to this, Mr. Cox denies making this statement. 12, that he did not ask Anderson to look for federal marshals. Mr. Anderson testified that on his own he looked up the names of federal marshals. Mr. Cox had asked Mr. Anderson to help in trying to find out who might be on the hit squad he believed was out to kill him. 13, that he went to Lieutenant Ron Wall's house to get help, and Lieutenant Ron Wall about CI2, which is Bill Fulton. Even R.W. testified that Mr. Cox wanted to discuss his ongoing problems with OCS when Mr. Cox and his wife came to R.W.'s house. 14, that he did not threaten Lieutenant R.W. Neither Mr. Cox nor his wife Marty believed that Mr. Cox said anything intended as a threat to R.W. during their visit. 15, that the only reason he had Trooper M.J.'s information was so he would know which jail as to go in order to post bail for a friend. Mr. Cox did in fact post bail for his friend. The only reference to M.J. was a yellow sticky note found during a search. See PSR paragraph 56. Mr. Cox did meet Trooper M.J. at the precinct. He knew where to go because he had Anderson look up Trooper M.J. 16, that the internet searches he conducted at Barney's computer were for the purpose of finding pictures. No evidence was presented to contradict this assertion by Mr. Cox. The photographs were used to create Robin Hood posters. 17, that CI told him of the 241 plan and he responded that it was not good. It was often CI who brought up the 241 plan and pressed Mr. Cox to be more specific. 18, that 241 plan was actually CI2's idea and was relayed by CI1. After Mr. Cox tried to downplay 241, it was CI1 who kept re-raising the topic. That he had armed security detail at KJ&P because he feared CI2 was going to kill him. Mr. Cox was fearful both of being harmed at overzealous law enforcement and by CI2. 19, that his directions to others in the security detail to shoot if he was in danger was in reference if CI2, Bill Fulton, jumps out and starts blazing away. The KJ&P security plan was always intended to be a self-defense measure. The whiteboard clearly indicates this to be the case. 20, that he wore body armor 24/7 because he was afraid of CI2 Bill Fulton. Mr. Cox did wear body armor nearly 24/7 and had expressed to his wife, father, and others his fear of the other militia members. Indeed, the government confirmed in an email that there was a plan by other militia members to off Mr. Cox. From Derek Espeland, sent Monday, June 14, 2010, 8:10 p.m. To Lisa Locasure, Sandra Klein, Bruce Milner, Sam Johnson. Subject, Schaeffer Cox Fairbanks. SC was exposed to as a self-grandizing fraud. He did not have a plan at all. Even if he had a plan, there were allegedly other plans to off, which is another word for kill, SC Schaeffer Cox 48 hours after the revolution began. Schaeffer Cox has gone from a cadre of 24 down to 2. Him and his number 2, Les Derby. 21, that he had attended the state court on February 14, 2011 because he was afraid of CI2 Bill Fulton would kill people. Mr. Cox maintains that he believed if he was arrested, some militia members would react violently. See paragraph 65 of PSR, where CI2 Bill Fulton says that he will react and rise up if something happened to Mr. Cox. There is a good deal of evidence that Mr. Cox was indeed fearful of CI2 Bill Fulton. The best evidence of this was when Fulton attacked Les Derby. According to some, pulled a knife and threatened to slit his throat after Bill Fulton was told by Zerby and by Mr. Cox that they did not have a plan to arrest judges. 22, that his statement to state judge were meant to warn her about CI2 Bill Fulton. Mr. Cox prefaced his statement to the judge with the phrase that there were a lot of people who would just as soon come to kill you in the night. Mr. Cox considered this as a statement of warning to the judge. 23, that he continued to interact with CI2 because he felt a duty to try to influence CI2. This statement was not material to the charged offenses and was simply Mr. Cox's belief. 24, that he thought that March 10, 2011 meeting with CI1, $300,000 whore J.R. Olson was only to meet the trucker, and he had not known of items being sold until he got into CI1, $300,000 whore J.R. Olson vehicle. Mr. Cox does not deny he discussed purchasing the silencers from CI2 Bill Fulton, but on March the 10th, he believed the purpose of the meeting was to meet the trucker as Mr. Cox was anxious to leave Alaska. It was not until Mr. Cox got into the car that CI1, $300,000 whore J.R. Olson told Mr. Cox that the weapons, CI1, $300,000 whore J.R. Olson said he wanted to mention these things on the telephone. 25, that he thought the purchase was going to be legal. Mr. Cox was repeatedly told by CI1, $300,000 whore J.R. Olson, that CI2, sodomite lover Bill Fulton, was a Class 3 firearm dealer who could sell silencers. However, Mr. Cox admitted he was told the sale was to be off the books. 26, the silencers were represented as being legal. The silencers were represented as coming from a licensed dealer, although Mr. Cox was told that these were going to be sold off the books. 27, that he never made arrangements to get real grenades. The March 10, 2011 recording reveals that when CI1, $300,000 whore J.R. Olson, said he had grenades, Mr. Cox was surprised. Mr. Olson, because I specifically told him what we want, yeah, Bill, I've got them, no problem, and because originally it was just the silencers, and I've got a bunch of those, but now we know he gets up in there, and we did a bunch of CIA crazy stuff, driving around, and he's sneaking around, meeting up with them, but he does have grenades, and they're $50 a piece. He'll come down on those, and they're the, what are they, the M74s? I don't know. The real military, legit, straight from the Army. So, Mr. Barney, that's still cool. Mr. Cox, yeah, well, Mr. Olson, I know it's Mr. Cox. That's tough. That's Mr. Olson, I don't want to say anything on the phone. I want to wait until I talk to you. And I said, I'll see what it looks. 28, that he was not interested in the grenades. On March 10th, Mr. Cox's primary interest was in meeting with the trucker and leaving the state with his family. 29, that he had the 37mm launchers for his business, for sailing and for golf. This was not a material matter. However, Coleman Barney also testified that there was talk about using the Hornet's Nest and launchers for a grenade tournament that never took place. 30, that the homemade silencers was for foxes getting into his chicken shed. Mr. Cox built the homemade silencer in 2008 when he received the How-To DVD. This was long before the alleged conspiracy commenced. 31, that the Sten machine gun did not work and was just for display. The ATF agent could not tell if the Sten was operable. No powder was found on the firearm. Mr. Cox had been rebuilding this firearm for many years as a World War II relic. Number 32, that based on a conversation with S.A., with the Bureau of Alcohol, Tobacco, and Firearms and Explosives, ATF, he thought it was okay to have unregistered silencer and machine gun. Mr. Cox did meet with the ATF agent Cahoon and came away from the meeting believing that homemade firearms that did not travel interstate commerce did not have to be registered. ATF agent Cahoon recalled the meeting but did not recall such a discussion. Both Mr. Anderson and Philip Clark were present and did recall a discussion about firearms and interstate commerce. 33. That he did not own any illegal weapons. Mr. Cox did not realize the Sten was illegal as he thought it was a homemade firearm that was also inoperable. Response. The objection is noted for the court's consideration. The probation officer maintains that the defendant provided testimony under oath, which testimony contradicted evidence presented and which resulted in a guilty verdict. No changes were made to the pre-sentence report as to the result of this objection. Objection 16, paragraph 133. Defense counsel wrote, while Mr. Cox owned numerous firearms, most were completely legal. The legal firearms included only one machine gun, which formed the basis of counts 4 and 5. There were a total of 3 silencers. The 2 CI1 $300,000 whore, Gerald J.R. Olson, showed to Mr. Cox and Mr. Barney March the 10th, and the homemade silencer, which formed the basis of count 6. Count 2 involved 4 grenades. Count 13 involved possession, a hornet's nest, and a launcher. Response. The draft pre-sentence originally attributed 13 firearms subject to regulation as pertaining to this case. However, the paragraph has been changed to reflect 12 firearms. Defense counsel submits that there are 10 firearms subject to regulation in this case. The guideline enhancement at paragraph 133 states that the offense involved between 8 and 24 firearms. The offense level is increased by 4 levels. It is noted that the parties' disagreement between 10 and 12 firearms does not affect the guideline enhancement in this paragraph. Objection 17, paragraph 135. Defense counsel wrote, while Mr. Cox was convicted of the aforementioned charges, we object to the 4-level enhancement under 2K2.1b6, suggesting that the firearms were to be used in connection with any other felony offense. The government suggested that 2K2.1b6 say that the firearm would be transported out of the United States in an appropriate use of the enhancement, as it was the government's own ruse that would have caused the firearms to cross from Alaska through Canada to the lower 48. Response. Pursuant to USSG 2K2.1, comment N14A, the guideline enhancement under USSG 2K2B6 applies in the firearm or ammunition facilitated or had the potential of facilitating another felony offense. In this case, there is no evidence that the defendant or Lonnie Vernon attempted to purchase the regulated firearms legally, and both individuals made numerous statements about killing others. The probation officer maintains that the defendant and Lonnie Vernon possessed silencers and grenades in furtherance of count 12, conspiracy to commit murder, for which both the defendant and Vernon were convicted, and in furtherance count 16, solicitation to commit of violence, for which the defendant was convicted. No changes were made to the pre-sentence report as a result of this objection. Paragraph 142, defense counsel wrote, defendant objects to this enhancement as the status of the intended victims as to counts 12 and 16 were already taken into account in the base offense level. Moreover, as the jury was required an element of each of these offenses to find that the defendant victims were government employees in order to convict for both counts 12 and 16, the addition of 6 more points amounts to impermissible double counting. Response. The paragraph assesses a 6-level increase for the offense involving official victims. The guideline applies when specific individuals are victims of the offense. USSG 3A1.2 comment. Do not apply this adjustment if the offense guideline specifically incorporates this factor. The only offense guideline in Chapter 2 that specifically incorporates this factor is USSG 2A2.4, obstructing or impeding officers. USSG 3A1.2 comment, emphasis added. The guideline for violation of counts 12 and 16 are found at USSG 2A1.5, conspiracy or solicitation to commit murder. The application note under USSG 3A1.2 clearly states that the offense level under USSG 2A1.5 does not take into account the victim's status. In this case, the enhancement for official victims was applied because the defendant targeted specific individuals who were government officers or employees, and the defendant's offense was motivated by the victim's status as government officers or employees. No changes were made to the pre-sentence report as a result of this objection. Objection 19, paragraph 144, defense counsel wrote, paragraph 144 suggests the addition of 4-level for use of body armor during the commission of the offenses in counts 12 and 16. However, those particular counts were very broad, time periods rather than discrete events, as do substantive counts. Count 12 under the period between August 2009 and March 10, 2011, while count 16 covers the period between November 15, 2010 and March 10, 2011. USSG 3B1.52b, which provides for a 4-level enhancement, states the defendant used body armor during the commission of the offense, in preparation for the offense, or in an attempt to avoid apprehension for the offense. USSG 3B1.52a, which provides for a 2-level enhancement, states the offense involved the use of body armor. Use is defined as an active employment in a manner to protect the person from gunfire. USSG 3B1.5 CMTN.1, this guideline requires the active employment of the bulletproof vest to protect oneself from gunfire during the commission of the offense, or in preparation or in the attempt to escape after the offense. The rationale for this guideline appears to be that during a violent confrontation, a person committing such an offense while wearing body armor may be emboldened. Here there are no violent confrontations and no immediate plan to engage in such a confrontation. The government conceded in closing argument that we're not telling you that it was going to happen today, that it was going to happen tomorrow, that it was going to happen next week, because the fact of the matter is the whole case is about when we're going to be strong enough. Day 22-4. The wearing of body armor while moving weaponry or while visiting RW or even on March the 10th, 2011 is not sufficient. For example, if there had been an actual attempt to commit the murder of government official, then this enhancement would clearly apply. Moving weaponry is not a crime of violence. The visit to RW was for the purpose of Mr. Cox seeking advice about his ongoing criminal case and warning RW about the intentions of some militia members. On March the 10th, although arrested while being shown illegal silencers and grenades, it is clear that Mr. Cox believed that he was going to meet with the trucker who would transport he and his family out of Alaska. Mr. Cox was not then preparing to imminently execute any murder of government officials. Mr. Cox was acquitted in counts 7 and 15 of carrying a firearm during and in relation to a crime of violence, including counts 1 and 12. Given that verdict and the fact that Mr. Cox routinely carried a firearm when he was wearing body armor, it appears that the jury believed that there was no discrete crime of violence that was committed, but only a conspiracy to do so at some indeterminate time in the future. Response. The court's ruling at docket 265 states that counts 1, 2, and 10 were crimes of violence. The defendant wore body armor numerous times throughout the investigation and during the commission of his offenses. Count 1 involved the defendant wearing body armor and meeting with CI1, $300,000 whore Gerald J.R. Olson to purchase a silencer and grenades, along with co-defendant Coleman Barney, who was also wearing body armor in commission of count 1. The court found in favor of the enhancement in Barney's case. No changes were made to the pre-sentence report as a result of this objection. Objection 20. Paragraphs 139 and 145, defense counsel wrote, defendant objects to the suggested enhancement for perjury as the alleged falsehoods in his trial testimony were either not material to the counts of conviction or not willful. Even if the aforementioned were in fact willful false statements, that those representations were not material to the counts of conviction. Material evidence is defined in 3C1.1, Application Note 6. Material evidence. Fact, statement, or information as used in the section means evidence, fact, statement, or information that, if believed, would tend to influence or affect the issue under determination. Moreover, Application Note 2 provides that the court should be cognizant that inaccurate statements sometimes may result from confusion, mistake, or faulty memory, and that not all inaccurate testimony or statements necessarily reflect a willful attempt to obstruct justice. Response. As previously stated, the probation officer maintains that the defendant provided testimony under oath, which testimony contradicted evidence presented and which resulted in guilty verdicts. No changes were made to the pre-sentence report as a result of this objection. Objection 21. Paragraph 127, defense counsel wrote, while Mr. Cox did put the government to its burden of proof of trial, he did not deny the essential elements of guilt as to all the charges. For example, he admitted that he had built and possessed a Sten machine gun that was found during the search of the trailer. He also admitted the possession, manufacture of the homemade silencer that was seized, count 6. He also admitted that the Hornet's Nest canisters and 37mm launchers that were located in the trailer were his, count 10. Response. If the defendant had admitted to the counts listed above prior to the jury trial, the probation officer would entertain the notion of recommending partial acceptance of responsibility. However, the defendant took the above listed counts to trial and he repeatedly denied responsibility for his actions. No changes were made to the pre-sentence report as a result of this objection. Objection 22. With regard to the Hornet's Nest and 37mm launchers, defense counsel wrote, I believe it should be noted in the body of the PSR pre-sentence report that both the Hornet's Nest canisters and the 37mm launchers are lawfully sold without any registration requirement. These are lawful items having legitimate uses. The charges in this case were brought because the government argued that the two items together could be used, and in this case the government argued were intended to be used as a destructive device. The fact that these items are readily and legally available distinguishes this case from other cases where the destructive device at issue involves wholly illegal items. The law on the issue is as follows. The definition of a firearm 2 includes a destructive device. See 26 U.S.C. 558-45A. See also U.S. v. Johnson 152 F.3D 618 623 7th Circuit 1998. If the objective design of the device indicates that no object serves no legitimate social or commercial purpose, subjective intent is not relevant to the analysis. See Johnson 152 F.3D at 628. However, if the assembled device or unassembled parts may form an object with both a legitimate and a non-legitimate use, then subjective intent must also be shown. CID. Finally, a destructive device includes any explosive, a weapon which will expel a projectile by the action of an explosive or other propellant. See 26 U.S.C. 558-45 F or J. Response. The information is noted for the record. No changes were made to the pre-sentence report as a result of this objection. Objection 23. Paragraphs 137 and 143. Defense counsel wrote, Mr. Cox's role in the offenses has been overstated. Lonnie Vernon was off on his own tangent, and Mr. Cox had no supervisory role over him. On June 15, 2010, Agent Sutherland wrote, Schaeffer Cox was exposed as a self-aggrandizing fraud. He did not have a plan at all. Even if he had a plan, there was allegedly other plans to off, which is another word for kill, Schaeffer Cox 48 hours after the revolution began. Schaeffer Cox had gone from a cadre of 24 down to 2. Him and his number 2, Les Zerbe. In a separate debriefing of CI2, which is sodomite lover Bill Fulton, fat, rude drunkard, Sutherland wrote, Benedict Arnold Bill Fulton wrote that an emergency meeting was called for the evening of Sunday, June 13, 2010 to discuss Schaeffer Cox's plans. The meeting was supposed to start at 8 p.m. Cox's second in command, Les Zerbe, arrived at 8:40 p.m. and Cox did not arrive until 9:30 p.m. By that time, those in attendance had consumed alcohol and discussed Cox's over-controlling character and that many in the movement did not care for him. The general consensus was that if Cox was to start the revolution, the movement have someone kill him after 48 hours. In that same report, CI2, Benedict Arnold Bill Fulton told Sutherland, Cox is a member of the leader of the Alaska Peacemakers militia. However, the CHS, confidential human source, Benedict Arnold Bill Fulton, believes this organization is defunct since Cox was exposed as a fraud during the meeting on Sunday evening. Response. The objection cites information that was dated in June 2010. Numerous events involving the defendant and his leadership over others involved in this offense unfolded over the following 9 months. No changes were made to the pre-sentence report as a result of this objection. Objection 24. With regard to this investigation, defense counsel wrote, the evidence adduced at trial and in discovery suggests that the attempt to induce Mr. Cox to purchase a silencer and a hand to grenades on March 10, 2011 was intended to enhance Mr. Cox's sentence rather than to further an investigation. Indeed, Special Agent Sutherland trial testimony supports this, as do emails from the AUSA. Benedict Arnold, Agent Sutherland testified that they were going to be arrested on state arrest warrants based on the conspiracy that was alleged regarding the 241 plan, and the FBI was asked to effect the arrest based on those state warrants. Then, as part of the takedown scenario, they were also going to be offered the opportunity to demonstrate whether they wanted to acquire suppressed weapons and grenades at the same time. In an email to FBI case agent AUSA Serpent Scrocky, talked about the attempt to enhance Mr. Cox's sentence by providing grenades on March 10, 2011. Given the short time frame, I don't have the time to adequately research whether this would provide additional sentencing enhancement, but it could. But however, much is known to me at present. On the surface, it would provide another charge of 5861, which would, in theory, provide another 10-year max sentencing structure, since they are distinct from the ones. Response. The objection is noted for the record and for the court's consideration, but does not appear to warrant a response from the probation officer. Paragraph 223, defense counsel wrote, while we completely agree with the comments in paragraph 223 that while defendant's conduct was serious, no actual physical harm to the targeted victims occurred, it is important to include the following facts as well. Mr. Cox planned to leave Alaska. By the time of his arrest on March 10, 2011, Mr. Cox was planning to leave the state. He had abandoned his home and his business. He was seeking a way for he and his family to leave the state of Alaska. He only stayed until March 10th because of the ruse the government played in delaying the arrival of the fictitious trucker who was supposed to transport Mr. Cox and his family out of Alaska. In addition, Mr. Cox was described by this point in time by CI1, $300,000 whore Gerald J.R. Olson, this confidential human source, said that Cox is trying to grow a beard and that Cox seems fatigued and really ready to leave the state. After March the 4th, 2011, meeting with Mr. Cox, CI1, $300,000 whore Gerald J.R. Olson told Benedict Arnold agent Sutherland, Cox seemed down and fugitive status seemed to be weighing on him. Cox is ready to leave the state. Cox is ready to meet the trucker who will transport him. Response. Defense counsel's statement had been incorporated into the pre-sentence report at paragraph 222A. However, it is noted that the probation officer's assessment at paragraph 223 did not take into account the psychological harm the defendant may have had on the victims and their families, and the paragraph has been changed to incorporate this factor. Okay, that is the objections to the pre-sentence report and the answers by Charlene Hensel, who I consider a traitor to justice and a traitor to good men and women of the people of America.